The ATF got hammered with lawsuits yesterday on day one of the official final rule, where they, being the ATF, where they think that they are the kings over Congress in this country. They decided they would start this rule, and today is day 2 of the 120-day period in which they will so graciously give you a free tax stamp if you register whatever you have with them that used to be called a legal pistol with a brace. And like I said, 3 lawsuits were filed yesterday. I know for a fact more are coming. Can't tell you when they're dropping. But I'm going to tell you a little bit about the 3, but I also want you to remember there's already been a lawsuit in effect for over a year, and that's the Second Amendment Foundation's lawsuit in North Dakota, where they were waiting for the official rule to drop, and now that it's dropped, I assume that that case will pick back up because it was paused, waiting for the rule to drop. So that's the Second Amendment Foundation case that was already going over a year ago when the ATF started talking about this with their proposal. The 3 that were filed yesterday brings the total to 4, and like I said, there will be more. And I'm going to give you a quick overview of the 3. I'll show you the lawsuits. I'll link to them down below if you want to dig into them. But they're all kind of suing along the same basis, the same lines, because we know, first off, the pistol brace rule has a problem with Bruin, right? Because in the Bruin decision, the United States Supreme Court said that in order for any violation of the Second Amendment, I'm paraphrasing, any infringement that the government has or wants to instill would have to pass the only test being the plain text of the Second Amendment, which none of this stuff is in there, obviously. And then the history and tradition of firearms regulation around the time when the Second Amendment was adopted in 1791. And I don't think it takes a brain surgeon to tell you that there was no history or tradition of regulating pistol braces or making people pay $200 for an item because it's considered under the NFA. It's so scary and dangerous. Whoa! All of it's bullshit. We know it. We've all known it for a long time. And there are also movements in Congress to attack the NFA. But I'm telling you about these lawsuits here now. So the first one on screen is the William T. Mock, Christopher Lewis, and Firearms Policy Coalition case. This was filed yesterday in the Northern District of Texas. You're going to hear that as a common theme because the Northern District of Texas is in the 5th Circuit. The 5th Circuit has been very friendly to firearms cases. It's Texas, right? And Cargill versus Garland, which we've talked about before, and Cargill versus Garland was a huge win, saying that the bump stock ban was unconstitutional and ATF was overstepping their bounds, and we won that on was it 13-3, if memory brings it back. I've been reading a lot of documents, but I think it was 13-3. So what they're looking to get from the judge in this case is to have the judge say that the final rule is unlawful and to set it aside, to vacate the final rule. Alternatively, or additionally, postponing the effective date of the final rule, issuing preliminary and permanent injunctive relief, enjoining defendants from enforcing or implementing the final rule, and in the alternative, declare that the final rule with respect to the short-barrel rifles and or defendants' short-barreled rifle laws, regulations, and policies and enforcement thereof violate the Second Amendment. In the alternative, issuing preliminary and permanent injunctive relief, enjoining the defendants from enforcing or implementing the National Firearms Act against common rifles with a barrel length of less than 16 inches that would take any SBRs out of the NFA by court order. 7, awarding plaintiffs costs of the action, reasonable attorney's fees, and equitable relief as just and appropriate. Again, this is the Firearms Policy Coalition case that was filed in the Northern District of Texas. The next lawsuit I'll tell you about that was filed yesterday against the ATF was from the Texas Public Policy Foundation. And this is their lawsuit. Their plaintiff is Blake Watterson, and what they're looking for from the judge are the following: enter a judgment declaring that the defendants lack the authority to promulgate the rule because Congress cannot delegate its legislative powers, and declaring that any NFA or GCA provisions delegating such authority are unconstitutional and setting aside the rule as contrary to Article 1, Section 1 of the United States Constitution. Enter a judgment declaring that the defendants lack the authority to promulgate the rule because Congress did not delegate the authority, and also setting aside the rule as exceeding defendants' statutory authority, meaning ATF cannot make law no matter how you slice it and dice it. Enter a judgment declaring that the rule, and the NFA and GCA, to the extent the rule is a valid interpretation of those Act's provisions, violates the Second Amendment, and setting aside the rule and the NFA and GCA to the extent the rule is a valid interpretation of those Act's provisions as being contrary to the Second Amendment. Enter a judgment declaring that plaintiff's AR-15 style pistol would not constitute a rifle or short-barrel rifle under the NFA or GCA if it was equipped with a stabilizing brace and his other accessories. Enter a permanent injunction enjoining defendants from enforcing the rule, enforcing the NFA or GCA in accordance with the rule, prosecuting plaintiff for possessing unregistered pistols with stabilizing braces, or promulgating additional rules that expand the definitions of NFA and GCA. Enter a judgment declaring that defendants lack statutory authority to make the rule effective immediately. Enter a postponement of the rule's effective date and a preliminary injunction under Federal Rule of Civil Procedure 65 enjoining defendants from enforcing the NFA or GCA in accordance with the rule. And one that I cut off is grant the plaintiff such additional or different relief as the court deems just and proper. Again, that is the case brought by the Texas Public Policy Foundation. The third case is brought by some actual U.S. vets. Remember, the pistol stabilizing brace and original intent was to help those people, specifically veterans, who were injured in a way where they could no longer shoot AR and AK style pistols due to some whatever type of disability they may have. And when it was approved, other folks with disabilities took part of this as well. And this lawsuit here that you can see on the screen was filed in the Northern District of Texas in the Amarillo Division. So you can see the strategy, right? Texas is the place to file suits against the government's unconstitutional gun control because Texas rules, basically. So of the plaintiffs, Brito and Tasher, sorry for the mispronunciation, they are vets from Wisconsin, and Mr. Kroll is a vet from Texas. And this case, what they're asking for is a temporary restraining order prohibiting the ATF from enforcing the rule, a preliminary injunction prohibiting ATF from enforcing the rule, a declaratory judgment declaring the ATF does not have authority to promulgate the rule conflicts with the relevant statutes, the rule is arbitrary and capricious, the rule is void for vagueness, the rule violates the separation of powers and the Second Amendment, or, in the alternative, the statutes granting ATF such unbridled power violate the non-delegation doctrine. Enter a permanent injunction prohibiting ATF from promulgating the rule, award plaintiffs their attorney's fees, and grant plaintiffs such other and further relief as the court deems appropriate. So there you go, guys and gals. The additional 3 lawsuits filed yesterday on day 1 of the ATF's rule brings the total to 4. There are going to be more. Trust me when I tell you. And I made a list of a bunch of things that were mentioned in these lawsuits, rather than to give you 3 individual videos about lawsuits. So I'll just go down them real quick. There's no history or tradition collecting NFA taxes, no history or tradition regulating pistol braces or AK or AR style pistols. And millions of folks have them, which would turn millions of people into potential criminals. ATF cannot make laws. Separation of powers. Congress is the one who legislates, not ATF, especially under the West Virginia versus EPA case from last year's Supreme Court decisions. There's a violation of the Administrative Procedure Act. The final rule, this was from the FPC case, the final rule is different than the proposed rule that came out, and specifically the worksheet 4999. Because it was different, they didn't follow the Administrative Procedures Act. It's a violation of the First Amendment because it would regulate marketing material from manufacturers and what they say and how it could be used to determine if the item's an NFA item. It violates the Second Amendment, obviously. It's unconstitutionally vague. It uses a balancing test, which is subjective, which is a violation of Bruin. All this stuff is a violation of Bruin, as well as Heller and all that stuff, McDonald, Caetano. The AG's authority is to enforce the GCA and NFA, but he cannot legislate. And they're referring to when Joe Biden said in the Rose Garden, remember I covered that last year, that if Congress fails to act, he would take action. So this is obviously at his bequest. It also mentions that braces were okay by the ATF for over 10 years, and millions of people bought them because of that. And now ATF is changing their mind, looking to make all those folks felons. I also got a lot of, sorry, my phone's going crazy. I also got a lot of follow-up questions or follow-up comments based off of the video I did yesterday with the updates that I learned while in the ATF's training seminar. When I said shockwave, I didn't mean the CAC shockwave brace. Honestly, I didn't even know it was called the shockwave. I just called it the CAC blade forever. I was referring to the Mossberg shockwave, the 12 gauge. And also, because there were so many questions on those updates that I provided, it proves how vague this rule / wannabe law is. And if that's so vague that people have so many questions, then it's unconstitutional. And I look forward to seeing what these judges say in rapid fashion, because we want the judges, obviously, to take action in all of these cases before that 120th day comes and goes. Now, my advice is to wait as long as possible. Again, I could be wrong. I hope I'm not wrong, but if I'm wrong, man, then things really gone sideways in 120 days. But I see this being stopped, because this is, I mean, this our generation's biggest attempt at a gun grab. You know, and this could possibly be the biggest government event that makes people criminals since Prohibition. And that's saying something. So I will keep bringing you the information about these lawsuits. Stay tuned if you want to know the ones that are coming soon. Also, stay tuned if you want to hear what these judges say related to temporary restraining orders or preliminary injunctions, because that could come quick, like quick. So subscribe to the channel if you want to stay in the loop. Hit that bell icon so you stay in the loop as far as when I put out information. I'm putting out a lot of videos lately, sometimes 3 a day. So check the channel back often. Don't wait on the notifications, because YouTube hates the Second Amendment channels right now. So all of their suggestions are going to push you this way instead of where you might want to be. So check us out every day here on Guns and Gadgets, the premier source for Second Amendment news. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see y'all on the next one. Take care.